A tribunal has ruled that misgendering is not harassment after Sandie Peggie claims she was forced to get changed in front of a trans woman. Hello, welcome to GBN Originals. I'm Miriam Cates. Now, in a recent ruling, an employment tribunal has upheld a nurse's right to refer to a transgender doctor as male, rejecting claims that such language constitutes harassment. This case, involving nurse Sandie Peggie and Dr. Beth Upton at Victoria Hospital in Kirkcaldy, Scotland, has brought the complex issues of gender identity, single-sex spaces and freedom of expression to the forefront of public debate. Now, the dispute arose when Ms. Peggie objected to sharing female changing rooms with Dr. Upton, who identifies as a woman but is biologically male. Ms. Peggie maintains that Dr. Upton should not have access to women's facilities, leading to a confrontation and subsequent legal action. Employment judge Sandie Kemp made a crucial decision in this case, rejecting NHS Fife's request to prevent Ms. Peggie from using male pronouns or terms when referring to Dr. Upton. The judge reasoned that compelling Ms. Peggie and her legal team to use terms they consider inaccurate would be unfair. This ruling is a significant victory for free speech advocates. It challenges the increasingly common practice of mandating specific pronoun usage in professional settings, recognising that individuals have the right to express their sincerely held beliefs about biological sex, even when these beliefs conflict with somebody else's gender identity. However, the fact that such a case had to be fought in the first place raises concern about the state of free speech in the UK. The attempt by NHS Fife to restrict Ms. Peggie's language and hold the proceedings in secret suggests a troubling trend towards suppressing certain viewpoints. The case doesn't exist, of course, in a legal vacuum. It follows other significant rulings, such as the Forstater versus CGD case, which established that gender-critical beliefs are protected under the Equality Act. This protection extends to expressing such beliefs, provided it's done in a way that doesn't violate others' dignity or create an intimidating environment. The case highlights ongoing controversies within the NHS regarding gender ideology. There have been accusations that the NHS is prioritising gender ideology over safeguarding women's sex-based rights and protecting workplace free speech. For instance, Lewisham and Greenwich NHS Trust faced criticism for implementing a trans inclusiveness policy that mandated staff to apologise if they used incorrect pronouns for patients. Similarly, NHS staff at United Lincolnshire Hospital's NHS Trust have faced pressure to comply with ideological positions on gender identity, with official guidance labelling the use of incorrect pronouns as oppressive. The legal proceedings have been contentious. NHS Fife attempted to ban Ms. Peggie from referring to Dr. Upton as a man during the tribunal hearings. Jane Russell, who represented Dr. Upton, argued that gratuitous misgendering had caused her client pain and harm, and accused Ms. Peggie and her legal team of contributing to a climate of hostility and hatred towards trans people. However, Naomi Cunningham, representing Ms. Peggie, argued that using correct sex pronouns was crucial to the case. She stated, "This question of whether Dr. Upton is a woman in any meaningful or salient sense is right at the heart of the claimant's case." The attempts to restrict Ms. Peggie's language and hold the proceedings in secret are deeply concerning. They represent a broader trend of attempting to silence gender-critical views and limit public discourse on these important issues. Joanna Cherry KC, the former SNP MP and lawyer, commented on the case saying, "We don't have compelled speech in Scotland." She described NHS Fife's action as a shocking waste of public money. The fact that a public institution like the NHS would attempt to compel speech and limit open discussion is a worrying sign for the state of free speech in the UK. It suggests that certain ideological positions are being given precedence over the fundamental right to express one's beliefs. This case touches on a fundamental question in our society. How do we balance the rights and dignity of transgender individuals with the rights and concerns of others, particularly women, in single-sex spaces? It's a complex issue that has required much careful consideration and nuanced discussion. On the one hand, transgender individuals may face significant challenges and discrimination in some aspects of life. They argue that being able to use facilities that align with their gender identity is crucial with their well-being and integration into society. On the other hand, many women express concerns about safety, privacy and fairness when biological males are allowed into female-only spaces. The outcome of this case could have far-reaching consequences. It may influence how organisations implement policies related to transgender individuals and single-sex spaces. It could also impact how similar disputes are handled in the future, potentially setting a precedent for balancing competing rights and beliefs in the workplace. However, the very fact that such a case had to be fought in court is a troubling sign for the state of free speech in the UK. It suggests that expressing certain views, even when based on biological facts and protected beliefs, is becoming increasingly difficult and potentially subject to legal challenge. As we continue to grapple with these complex issues, it's crucial that we approach the debate with empathy, respect, and a commitment to finding solutions that protects the rights and dignity of all individuals, but also speaks the truth. As we move forward, we must ensure that our society remains one where differing views can be expressed and debated openly without fear of legal repercussions or professional consequences. Only through open and honest dialogue can we hope to navigate these complex issues about gender identity and rights in a way that respects and protects all members of our society. This is Miriam Cates. Thank you for watching. Don't forget to subscribe to GBNews YouTube for more.
You know, free speech is over. This whole bill is a disaster for employers and needs to be scrapped.
And because the Equality and Human Rights Commission is saying that if the way this bill could be interpreted, if you start giving your view on the transgender issue, for instance, someone can say, that's out of order.
Yeah.
Conversation over.
Your words offend me.
Exactly.
In my workplace, and therefore...
And the publican then may be required to end the conversation,
I hate
throw them out, or throw them out the pub.
I mean, it really is 1984. We are living it now, isn't it? It's newspeak. This is what you're allowed to say, nothing else.
Yeah. I think that when it comes to the pubs bit, common sense would probably prevail, and I think it'd be very unlikely there would be any action taken in a pub. It could happen, but I think it's unlikely.
But the fact it could makes it wrong.
But the intention of this is to stop harassment in the workplace.
Yes.
So that's the idea. What seems to have happened, according to the Equality and Human Rights Commission, is that's now being literally interpreted by employers, which means in the workplace you couldn't discuss, you just mentioned transgender issues, that would be a good example, but couldn't discuss basically contentious issues in case someone overhears you. So what started as being able to protect employees either from being intimidated by other employees or by customers or clients or something like that has gone one stage too far because of the wording.
Yeah, can I just give you the actual wording? I think it might be useful.
Yeah, go on.
So it's the quote is, unwanted conduct that has the purpose or effect of violating the recipient's dignity or creating an intimidating, hostile, degrading, humiliating or offensive environment.
That's the point, yes. I mean, and so effectively that's stopping harassment. So the intention...
Well, it's stopping your feelings being hurt.
Well, it goes a bit further than that. I mean, hostility could be more than just feelings hurt. Intimidation...
Offence?
Intimidation would be bullying, and creating any environment which is uncomfortable for another worker to operate in.
We have these laws. We have law upon law upon law in the workplace to stop this. We seem to be holding on to the tail of the dog and hoping the dog won't move, when really we should just go back to school and teach our kids to just be polite and respectful to people, rather than bringing in yet another law that can be misinterpreted to stifle free speech.